Good afternoon, everyone. I am Paul Peterson. I am the Director of the Program on Education Policy and Governance at Harvard University. We have a fall colloquium series, and we will have our next event in that series on Thursday, October 27th at the same time, 12:15, and Robin Lake will be speaking on the state of the American student, recovery and reinvention after COVID. But today we have Rocco Testani as our guest speaker. He is a partner and the co-head of global litigation at Eversheds-Sutherland law firm based in Atlanta. He's also a co-leader of the firm's U.S. business and commercial litigation team and is a member of the firm's executive committee. He specializes in school finance cases and equity and adequacy law litigation and in other governmental issues involving critical education issues. So we are very grateful that he is here today to share with us his insights on the way that the role that state courts play in a federal system. In these school equity and adequacy lawsuits and more generally the relationship between the state and the federal court systems. So without more ado, let me turn it over to Rocco Testani.
Thank you, Paul. So I'd like to start this afternoon with a very short history of American education litigation, beginning really with Brown. And of course, Brown is the Supreme Court case from 1954 that established the principle that separate but equal has no place. And of course, it was decided under the Equal Protection Clause of the federal Constitution. And 50 years of litigation plus followed that decision in the implementation of the Brown decision. That was the peak, really, of federal court involvement in education and the follow-on cases. And I say that because the next case, San Antonio versus Rodriguez, which was a 1973 US Supreme Court decision, was a case in which the court was looking at disparities in education funding in the state of Texas. And there were severe funding disparities between wealthy areas of Texas and poorer areas of Texas. And the plaintiffs in that case, as a follow-on to Brown, were making the argument that education should be considered a fundamental right under the 14th Amendment, and that wealth should be treated in the same manner as race, that it should be considered a suspect classification that would be subject to strict scrutiny under the 14th Amendment. So the plaintiffs presented that case, but in a 5-4 decision of the US Supreme Court, the court held that there is no right to education under the federal Constitution, and that wealth is not equivalent to race and is not a suspect classification. So the effort to translate or to build upon Brown in San Antonio versus Rodriguez failed in the federal courts. So the action in this area turned to the state courts, and Serrano versus Priest were several decisions from the California Supreme Court. And like the Texas case in Rodriguez, involved disparities in school funding across the state of California based on the property wealth of the particular district. The facts of Serrano, like the facts in Rodriguez, were pretty severe. To give one example that the court focused on, 1 mil of tax in Beverly Hills, obviously a very wealthy area, generated $50,000 in tax revenue. Just east of LA, in a community called Baldwin Heights, 1 mil of tax would only raise $3,000. So the problem is obvious. You know, wealthy communities did not have to tax themselves to the extent of poorer communities, and yet could raise substantially more revenue. So that was the factual scenario at issue in Serrano. And California Supreme Court found in that case that such a situation violated California's Equal Protection Clause under its constitution. So Serrano opened the door, as they say, what happens starts in California doesn't stay in California. So sure enough, Serrano really led to many states not only having what was called equity litigation under state constitutional law, but also led to a lot of reform in the 70s and 80s. Most states, when you look at their education funding formulas, were revised in response to Serrano. And so what most states did was put into place new formulas that had more state level funding to equalize funding across a state in light of the differences in property wealth. So that was the equity litigation. The next case that I've wanted to speak about is Rose versus Council for Better Education, and that's a 1989 decision from the Kentucky Supreme Court. And the significance of Rose is that as Serrano was concerned with equity, that is differences in funding across the state, Rose was concerned with whether there's sufficient funding, adequate funding for public schools. And the question in Rose was adequate for what? For what purpose? And it traveled under, instead of an equal protection theory like in Serrano, the theory in Rose was the education article of the Kentucky Constitution. Every state has some pretty usually vague reference to education as a matter that the state is obligated in some manner to provide. So this education article in Kentucky was the basis for the claim that the funding there was insufficient or inadequate to reach state standards. And so the Kentucky court, the Rose court, articulated several what they called capacities that students needed to be able to achieve. And the finding in Rose was that the funding levels in Kentucky were insufficient to meet those capacities. So that's my short history of education litigation in the US that sets really the groundwork for almost everything that's followed in that time frame. As I mentioned about Rose, it was based on the Kentucky education article. I've put up here on the screen sort of examples of the kind of language that is the basis for these cases. And so I put up 4 examples. So because we're in Massachusetts, I thought we should focus on that. Plus, it's very flowery language, so I wanted to talk about it. This is, of course, sort of 18th century language, but so you see the example, the duty of the legislature and magistrates to cherish the interest of literature and the sciences and all seminaries of them, especially public schools and grammar schools in the towns. So that language from the 18th century was ultimately litigated in a case called Hancock, which was the major school funding litigation in Massachusetts. And we'll talk a little bit about the significance of this kind of language and then how courts are supposed to interpret it in a way that decides these cases. The New York language is very brief. The legislature shall provide for the maintenance and support of a system of free common schools. That language has led to significant litigation. The main case was the Campaign for Fiscal Equity case that went on for a number of years and led to an extensive remedy in 2006. New Jersey is probably the most active and famous of the adequacy cases because it's gone on for so long. There, the language is thorough and efficient system of free public schools. And that's a case, it's had different names. The most, I think, common name is Abbott. And that litigation is ongoing. It's been almost 30 years of litigation in New Jersey over the adequacy of a set of their public schools, primarily serving low-income students. There have been 20 plus decisions by the New Jersey Supreme Court in that litigation. Again, trying to interpret and then implement what does this provision mean. Florida case, which I am very familiar with, having worked in that state on their adequacy litigation, had a much more current language as the result of an amendment to the Florida Constitution. In 1998, the voters passed this provision. And the significance of this one was there was an effort in 1998 to try to put some sort of meat on the bones of a broad sort of adequacy provision. And what was passed at that time was a provision that said adequate provision shall be made by law for a uniform, efficient, safe, secure, and high quality system of free public schools that allow students to obtain a high quality education. The litigation involving that provision lasted 9 years and a long trial, and the Florida Supreme Court decided ultimately that case in 2019 on the basis that the state had met that obligation under the Constitution under a very deferential standard of review. We'll talk about that in a minute in terms of how the courts look at these cases. So what are the kinds of claims that are typically brought in these both equity and adequacy cases? The first point up there really is the equity kind of litigation that I talked about as far as Serrano and Rodriguez are concerned. That is, funding available to schools is improperly dependent on district property wealth and not on educational cost or student need. And so, as I said, that kind of case led to reforms that generally led to equalization of funding at the state levels. Then the next item on the slide is the adequacy claims. Inadequate funding, and this is really the central sort of theory or premise of these cases. Inadequate funding causes low student performance on state assessments and other outcomes like graduation rates, particularly among disadvantaged students. And this focus on I want to focus on the word cause, because that really becomes, as we see in the cases, the central sort of evidentiary question in the case. Have the plaintiffs established causation? Can they prove that funding levels actually lead to certain student outcomes? And so that's the sort of expert issue that involves a lot of time and effort and study by researchers like Paul and others who have worked on this topic. There's a lot of focus in these cases on teacher experience and quality and the allocation of teachers. This is a significant point, not only because I think the general consensus that teacher quality is extremely important in terms of an instructional input, but it also implicates the question of who is responsible for that. These cases, both adequacy and equity, are typically lawsuits brought against the state. So the State Department of Education, the State Commissioner of Education, the State Board of Education, the governor. And depending on the state's role in managing schools can be very limited. That school districts under state constitutional law in many states actually are charged with managing and controlling the delivery of education. And that involves important issues like hiring teachers, evaluating teachers, recruiting them, getting rid of teachers who are not doing a good job. And so one of the questions we deal with in these cases is who's responsible if the schools are not staffed with high quality teachers or teachers appropriate for their student body. Class size is another one of those topics that comes into play in these cases. How large, what's the right size of the class? Trade-offs, of course, exist on this issue where you might want to have a low class size, but you can't find enough good teachers. So what's better, a class of 25 or 30 with an excellent teacher or a class of 15 with a mediocre teacher? And the trade-offs that are having to be made, of course, are management decisions ultimately at a school and a district level. What are the curricular and extracurricular offerings? Is there challenging curriculum in low-income schools? Are students being given an opportunity to be challenged with high expectations no matter where they attend? That's a question that gets addressed in these cases. Structural materials, technology, are those up to date? Are they working? Facilities is always an issue in these cases. What is the condition of the facilities? Are they interfering in some way with student learning? Are they safe and secure? This is an issue that was raised more recently in COVID litigation over whether schools were safe for both students and staff. And then what kind of programs are there for students with particular needs, whether it be ELL students, English language learners, low income students with disabilities? How are those programs designed, and are they, again, adequate? Because the focus in these cases is very much on low achievement student groups and what is being done to raise achievement. The legal request in these cases is typically declaratory relief. They ask the judge in the first instance to declare that the system of funding is unconstitutional under the state constitution. And then there's a period of remedial stage, and that is they ask the judge initially find liability, that it's inadequate, and then send it to the legislature to figure out, usually with some parameters, what is needed to fix the system. And that can take a long period of time. And frequently what happens is a lot of back and forth between the trial court, the appellate court, back down to the trial court, and then there's a period of time trying to design a remedy. And then that gets evaluated. And that's how New Jersey, for example, has had 20 decisions back and forth over whether what the legislature there has done was sufficient. Because I've defend states in these cases, I want to talk a little bit about the defenses, but it's also an interesting question because these are important, both legal and factual issues that get developed in these cases. The first bucket of defenses, and usually the first step in these cases, is to assert what I would say are procedural or just kind of legal defenses, is to claim something the court should entertain at all. And before we, obviously go to the expense and time of litigating the merits of the case, does this case belong in court at all? And so the first item that's usually filed is a claim by the state that these really are political or policy questions, how to fund schools, how to operate schools. There's not consensus around that. And these are policy disagreements, and the judiciary does not have a particular expertise in resolving those any different or any better than a legislature or the executive branch of government. So it's a separation of powers question. Can the court answer these questions? Is the court empowered to answer these questions under the state constitution? And this argument really comes out of U.S. Supreme Court's decision in a case called Baker versus Carr, which dealt with voting rights in the early 60s. And the Supreme Court established a set of standards about whether a court has the authority, the competence to decide issues that are political or policy oriented. And what the courts look at here is, are there what they call judicially manageable standards to decide the dispute? That is to say, are the questions susceptible to a judicial determination, yes or no? And that's the question that we pose, on a defense perspective. Our argument is, look, you can, assemble 10 educators or 10 economists around the table to talk about these issues, and would there be some level of understanding or consensus about what is, sort of needed? What is the best way to do something? Are these gradations of sort of policy determinations? And if they are, then does that belong in a court? And does the text of the Constitution in the state make a determination about, is that committed to the judicial branch or to a policy branch of government? So those are an initial set of considerations that are asserted initially. Standing is another one. Has the plaintiff suffered an injury in fact, or is it a hypothetical question, or is it a policy debate as opposed to have I been actually injured? This is after all a lawsuit, and typically a plaintiff has to claim an injury. And so that's an issue that is raised often. And then the last sort of what I would say is procedural and legal point touches on the point I was making a little while ago, which is who's responsible. Is it if the state is sued, does the state have the authority to fix the issue? Or is it a management question? Is it a question that belongs to the school district? And so failure to join an indispensable party is a way of saying, do we have the right parties in front of the court here or not? The parties that could actually, who are responsible, and the parties that can actually remedy whatever problem might be found. So once we get beyond those procedural or legal defenses, which probably fail more often than they succeed, we then talk about the merits of the case. What are the merits issues? One of them, and I would say this is a bridge issue, and that is, what's the proper standard for the court to evaluate this? So if we've not been successful in convincing the court that really the court's role here, or doesn't have a role here, the second part of that is, if you have a role, what is the way for you to evaluate the evidence? Are you going to be deciding sort of from scratch, I'm going to decide as a judge or as a court, what's the best way to run a school? What's the best level of funding? Or am I going to take a deferential approach saying, even though I believe the court has a role here, should there be deference paid to the policymakers in the first instance, the elected representatives of the people who've designed the system, who've implemented the system, and keeping in mind that we're really talking about adequacy of funding, and funding of K-12, at least in the states, is the single largest item of any state's budget, and I think that's true probably in every state. So when a court is being asked to strike down appropriations acts, is being asked to strike down and to say revise the single biggest part of a state's budget, that's a big deal. And so should a judge come into that with some level of deference? And so this argument is consequential, because if you say, I'm not going to decide about the best system, I'm not going to decide if it were me how I would run the schools, or I'm not going to decide if I'm just going to accept what the plaintiffs and their experts say is the right way to run the schools. I'm going to have to evaluate the evidence through a lens that my role here is limited. And unless it's sort of irrational or arbitrary, I'm not going to get involved. And so that debate about what is the right evidentiary standard is really important in terms of the outcome of these cases. The second merits issue that I think is really important is causation. I touched on this a minute ago, and that really gets into the econometric evidence, the other social science evidence about the relationship between funding and student performance outcomes. And there's obviously a lot of literature about this going back to the 1960s. And that is, what role do schools play? What role does funding in schools play in terms of moving the needle on student performance? And this is, of course, a greatly debated issue. And so in these cases, the experts line up on both sides of this issue and on both sides of that topic. And what are the other considerations here? Management of schools. What role do schools have generally, and what role can schools play to remedy, for example, out of school factors or address out of school factors? And then, fundamentally, these cases are called adequacy for a reason. Adequate, the argument is sort of adequate in what sense? Adequate to do what? That is to say, how do we know a school system is adequately funded or not? So Putting things in context is another part of the evidentiary presentation in these cases. I often will use the example of the National Assessment of Education Progress, the national testing system we have. And the standard that is looked at is, are students proficient on NAEP, in reading and in math, in early grades, middle grades, and high school. And on that NAEP program, Massachusetts is consistently the highest performing state on NAEP, and yet half of the kids are not proficient on the NAEP standard in Massachusetts. So when we look at the evidence in the states, and the argument is, how can it be that a school system is adequate or adequately funded if half the kids or more than half the kids are not proficient? You have to ask yourself, what's the measuring stick? If we know that the best performing state in the country is half the kids aren't proficient, then we really need to consider what are our standards, what can reasonably be expected, and how are we measuring this? Are we measuring it in a sort of pedagogical sense? Are we measuring it in a constitutional sense? And sort of, are we talking about baseline? Are we talking about, trying to reach a higher level? So that's very important, the context of what we're measuring. As I mentioned, expert witnesses play an extremely important part in these cases on both sides, both plaintiff and defendant. And the kinds of experts, as I mentioned, economists, school finance experts, statisticians, education policy. Oftentimes, of course, there'll be what I call in-house experts, whether at the Department of Education in a state or within a school district. Teachers often will testify, principals will testify, school superintendents will testify about their experience in schools. And then what kinds of studies or analyses would be presented by these experts, from what I would say is very simple comparative analyses, literature reviews, meta-analyses, studies of studies, applied analysis, and then down to what I call anecdotal evidence, which is, I saw it in this school and that worked, and therefore it must be able to work everywhere. So there's a range of evidence that gets heard in these cases. And by the way, I should mention, of course, these cases are decided by judges, not by juries. So it's a bench trial in all these cases, and so you're speaking to someone who is relatively sophisticated, and certainly in the law, maybe not so much on these issues, but that's the nature of being a judge. You have to learn the stuff as you hear it, as it's presented to you. The big issues in these cases, and this is kind of a microcosm, I guess, of the big issues in education generally, which is, how important is money? There used to be this sort of caricature of the defense of these cases, that money, that there's sort of money doesn't matter literature. That really, of course, was never what the literature said, but that is the caricature of it. Obviously, money is essential to running schools, as it is to running any operation. But the question is, how much is needed? And how effectively is it spent? Are there places that spend it more effectively, more efficiently? And how meaningful of a difference would additional funding make in schools, if any? A lot of the emphasis in this litigation is, what are schools that do things well? What are school districts that do things well? What are states that do things well? And how do they compare to similarly situated schools and states that serve similar student populations? And what do we know about the way that they're organized that produces better results? And is the difference money? And so those are important questions that get taken up in these cases. And the fact is, 80% or so of the funds are spent on personnel. So in all schools. And so the question is, what is the really room for making a difference in schools? And really, is it about personnel policy? I mean, to a large extent, it boils down to that, which is, how good are your staff? And what are you doing to make sure you have the best staff and recruit and retain them? We deal with, in these cases as well, questions about the role of accountability, which of course has been a popular topic in education circles for the past 20 years, but it connects to the management question. Is there what role does choice play, whether it's charter schools, whether it's open enrollment to the public system, whether it's vouchers? What role does that play in improving schools or rating schools? If you grade them, for example, as they do in Florida, and release that information, what kind of effect does that have on improvement if that's simply known to the community about whether you have an A school, a B school, a D school, and does the school improve when they're at a low grade? And these are policy questions. Does that work or not? And that's a topic that we get into in these cases. Another important topic is what do we make of the Common Core standards? What role do they play in these cases? Oftentimes what's litigated is the plaintiffs in these cases come in and say, look, on our state assessments, which the policymakers have decided are the proper standards in our state academic standards, we've decided what level of knowledge students should have in each grade at every grade level, and we've set cut scores for that. And this is the determination point. What's the cut score of proficiency? And if 60 or 75% of the kids are not proficient at a grade level on a subject matter, plaintiffs will say, how could that be adequate? And it's not, and this connects to the separation of powers question, because they'll say, look, the policymakers have decided here what is adequate, what is sufficient, and this is what our students should know, and large numbers of them are not achieving at that level. So it must be that there's something wrong, and it must be that is a lack of funding. And so questions about what do the standards represent, how are the cut scores set, what does it mean to set a cut score, and ultimately, is the theory that that's the minimum, or is that what in other circles we call a stretch goal, and that there's a benefit to having stretch goals because people work harder to get above a baseline, even if the stretch goal is not actually achieved. Those are questions about what does it mean to set these standards, and that's a key issue in these cases. Some practical considerations are, okay, we have other obligations as a state to fund things beyond schools, even though it's the biggest element of our budget, but there are other things like Medicaid, for example, which is the next largest item of most states' budgets. And so there's that, which we need to consider. There are other things that the public demands, services, roads, public safety, public health, any number of other things that the public demands be provided by the government. And so if we're in a world of here's our revenue, how do we allocate that? And this gets back to the question of what role can a court really play here in sort of deciding which priorities should be given priority. Now, the argument on the other side is, well, there's this hook in the state constitution that says schools, have to be provided for and they have to be adequate. Therefore, that one should take precedence. But as a practical matter, of course, these other demands on government are real and important, and perhaps as important. So that's an issue that we often will present evidence about. And then the last point is sort of what can courts do to enforce their orders? So let's say a plaintiff is successful and they get a court to determine that, in fact, the school system is inadequately funded and there's a finding of liability, and it gets referred to the legislature to fix. And let's say the legislature doesn't fix it, or doesn't fix it in a way that the plaintiffs are satisfied with, or the court is satisfied with. What then? The courts do not have a police force, and the courts do not have the ability to force something to happen other than through its power to make pronouncements. Now, there are other things like contempt sanctions and trying to hold public officials in some way or another responsible, whether that's through fines or some other measure by the court. But fundamentally, you can't jail the entire legislature if they don't respond to this. So what do you do if the political branches of government say, thanks for that, but we're the legislature. we're the executive branch, and we're just not interested in what you have to say about this. And there have been a couple states where the envelope has been pushed on that point, and ultimately the political pressures in those states led to compliance. But it's still a question. It's a question about what is the power of the court in these cases. I'll just sort of conclude with a couple of sort of slides about sort of what kind of evidence, would we present? What's the typical sort of exhibit in these cases? From a defense perspective, one of the things that we like to show is, so what is the story of education funding trends in the United States over the past, say, 50 years? And so this exhibit is one we used in a case, and it was real. This is real dollars, 2018, $19, and this is the trend. So this is what we do know about spending per student in the United States over, almost a 50-year period from 1976, cut off here to 2016, 17. And, this is not news. It's not headline news here. I think we know that this is what the trend in funding has been for public education. It has been almost linear in its rise. And, in this last period here, it's almost $15,000 per student in real dollars. In 1976, it was, half that. And so we've spent a lot more in public schools in the last 50 years. And if we were to sort of bring this up to date to 21, 22, those numbers would be considerably higher, because we still experienced a dip, in the Great Recession was bad. And it really did impact revenues and spending. And in fact, as you can see from this chart, in real terms, spending went down in that 11, 12, 13 timeframe. But it has risen as revenues have gotten, property values have gone up, income tax revenues have gone up, and obviously the federal dollars most recently have been extraordinary. So that's one thing we know. The other is, what do we know about outcomes? In a broad sense, what we know about outcomes is that and this is on NAEP, which is really the best way to look at this over time and across the country, that NAEP scores have been flat. That's probably the best thing you can say about them. And I think when they get released this month, here next week, or whatever it's going to be in the next couple of weeks, I don't think there's going to be any surprise that there's going to be a drop off, largely to the pandemic. But I think the trends have not been great generally. And so we have flat achievement growth or achievement results, and we've got very substantial funding increases. So, again, why do I show these two charts? It's to make my broad point, which is, is money really the driver here or not? And so again, those were exhibits. This is the last one I'll show, which was an exhibit we presented. Some of the language, this was in one of the exhibits in our Florida case. Recall that some of the language in these constitutions talk about efficiency, and that that should be an efficient system of public education. And so what this chart does, and this is from one of our, Paul, I think, was on the study as well, but so was Eric Haneychek, which was one of our experts in these cases, is sort of on the horizontal axis, looking at spending increases in real dollars between 1990 and 2009. These are increases, funding increases in real dollars on the horizontal. On the vertical, we're looking at increases in NAEP scores in that period. And so where's the best place to be? The best place to be, if you're focused on efficiency, would be the upper left corner. And the state that is in the upper left corner is the state of Florida. So they spent the least amount, or increased their spending the least amount, but had the best results, had among the best results in terms of improvement. Where you don't really want to be is off to the right bottom. There aren't many in the right bottom, but Wyoming's one that spent a lot more money, did not get near the improvement that a state like Florida did. And then you can see the array. Massachusetts did pretty well, but they spent a lot more. So the question becomes, what's the right amount to spend? What is the sweet spot in terms of spending and getting improvement results? And I think what this generally shows is it literally is all over the map. you can spend a lot of money and get very little results. You can spend a lot of money and get great results. You can spend a medium amount of money and get good results, medium results, low results. And you can spend, not a lot of extra money and get great results. So again, these are different ways of trying to make the broad point that it's not simple in the sense that if we just spend more money, then we know we'll get great results. I do want to finally, and I do mean final now, touch on the other side to this. And I obviously sort of slanted towards the defense of these cases, but I do want to talk a little bit about some research that's become important in these cases from the plaintiff's perspective, and that is what I call the money drop research. And the two leading sort of articles on this have been the Jackson, Johnson, and Persico article from 2016, and then the LaFortune, Rothstein, Schanzenbach article from 2018. And these articles, I focus on these two in particular because some of these folks have appeared as experts in these adequacy cases, but also because their research has been well publicized, and their research design has been, I think at the time it came out, considered novel and interesting. And what they looked at was the school finance reform events. And so we've had a lot of litigation over 50 years. Courts have implemented, found liability, implemented remedies. And at that point in time, when the remedy gets implemented, there's a rise generally in funding. And so they use that as an event that they say is random. And therefore you can study pre-remedy and post-remedy. And they say, based on fairly complex statistical analyses, that when we look at trends and performance pre-money drop and post-money drop, we see that in the Jackson case, spending $1,000 more a year for a number of years, 12 years, will improve educational attainment and wages, adult wages, in significant ways in those schools and districts that had the benefit of these school finance reforms compared to the schools that didn't. And the exposure to that kind of reform, because they were able to connect it to individual students from census information, the longer the exposure, the better your results are. And so that's one of the items that really gets focused on. The Rothstein is a similar approach, looking at test scores, but also finding kind of, and a later period of time, similar approach. And, basically the same idea. When the school finance reform hits, we see better results in those states that had the benefit of those events. There are many issues with these studies from my perspective and from the perspective of others who've looked at them, and they're complicated. But I see that we probably want to conclude, at least from my remarks, and take any questions that our group here has or online.
Well, thank you, Rocco Testani, for your presentation. It's just a fascinating story about the way in which social science gets involved in legal policymaking and really important constitutional questions. So the question that I would like to raise initially here is, are these experts just sort of window dressing, or do the judges pay real attention to what they say? Because the judges, as you've said, they're experts in the law. They're not experts in school finance. And do they hear, on the one hand, one group of experts say this, and on the other hand, another group of experts say that? Don't they just sort of say, I'm not sure I believe any of this stuff. I'm going to make up my decision on other factors?
I think what we know about that is what you see in the published decisions, which is in the states that have gone down a track of a finding of liability and a finding of an extensive remedy. The expert witnesses are prominently highlighted as evidence that, not to invoke science, but we know this. This is, in a sense, definitive. It's not really definitive, but in deciding the evidence. And again, this gets back to my argument about deference. What's the role of the judge? If you can convince the judge that it should be deferential, then we've got competing experts saying, well, on the one hand, on the other hand, then perhaps the deference, if it's, if we're successful in saying, here's the right standard, then I think it does end up, look, this is debate. This is a debate. It's not settled, and I'm not going to resolve the debate here in my courtroom. Judges who perhaps see their role as being more active in assessing the evidence will, in fact, delve into the expert testimony and talk about it. And I'll say talk about it in the sense that at the end of these cases, the lawyers are asked to prepare proposed findings of law, conclusions of law and findings of fact. And so the judge's decision will often be very much informed by what the parties' lawyers will submit. And of course, the lawyers will, do fall in love with their presentations and will put in their version of how that expert evidence shakes out. But no, I think in cases where there's a finding of liability, the judges do in fact talk about that and rely on it. So I wouldn't say it's window dressing at all. Now I think it's informed very much by the on the ground evidence or the anecdotal evidence. Is that, well, that expert evidence was supported by the superintendent and supported by the principals and supported by the teachers, who all validated that, if they had more resources, they could do better things and they could get better results.
All right, I have other questions, but is anybody else have a query that they would like to offer?
I'm sort of intrigued with the ability to maybe reopen Rodriguez. The court seems to, in some opinion, to be open to reopening old cases, so to speak. So what's the devil's advocate's angle to retry that and see if we can move it into the federal system?
Yeah, let me just add to that. So Rodriguez was settled in 1973. They said the federal government's not going to get involved in these equity lawsuits, but that was a long time ago. Are they ready to reopen the
Where's the
conversation?
weakness?
Yeah.
Where's the foot in the door?
Yeah. So there was an effort to do this recently, and it ultimately failed, although it got further than I would have thought it would have gotten. And that was in the Gary B. versus Snyder case, the Michigan case that was focused on the Detroit public schools and a very sad state of affairs in Detroit that was highlighted in that case that was brought in the federal court in Detroit. And the argument was that look at this situation in Detroit under receivership, state receivership, and look at the outcomes of the students, look at the condition of facilities, and look at the low performance, particularly of a highly concentrated racial minority school district, with the importance of education, working off of the Supreme Court's not only obviously Brown decision, but other decisions like Plyler versus Doe and other decisions that have been made by the Supreme Court, including decisions out of Michigan in the affirmative action cases, the Grutter case and the law school case, and where the court had talked about the importance of education. And again, so the thought was that this is a good case to bring and to see could Rodriguez be revisited, and the plaintiffs there were basically saying to the trial court, you should revisit this in a sense. I mean, they obviously the lower court can't overturn the Supreme Court, but they could say, look, our facts are these, the law is developed in a certain way since the 70s, and we think this is an example of really there's a violation of the Equal Protection Clause here. And the trial judge in Detroit agreed that this was a violation of the federal Constitution. These conditions, these funding levels, what was determined to be inadequate or unfair or inequitable educational resources and outcomes. That case was appealed to the Sixth Circuit, and was because the court took the case, vacated the district court's decision, and before the Sixth Circuit decided it, it was settled by the state. So we don't know. That one was the most promising one to make its way maybe back to the Supreme Court, and it got resolved by settlement. So I don't think that's probably the end of that kind of an effort.
Can you just speak to the detail about how it was settled?
It was settled, as many of these cases do get settled, which is a commitment by, there was a change in the governor. So Governor Snyder and now Governor Whitmer came in. And oftentimes it happens when there's a change in leadership in the governor's office or in the legislature. The new governor had a different view about school funding than the old governor. And so the new governor settled with certain financial enhancements to the Detroit school system. And that was sufficient to settle the case. So there were commitments made to provide more funding to Detroit.
Right. So how about the fact that a lot of money is being dumped on the school system? I suppose I shouldn't use the word dump, but you use the word dump, so I guess I can use it.
I said
Money
dropped.
dropped.
Yeah.
So a lot of money has been dropped on the school system by the federal government as part of the COVID relief packages that have been enacted into law, and also because of the increase in property taxes. Property is worth a lot more today than it was just a few years ago, and also there's been a huge increase in revenue to states, and so they're able to provide more money. So really, schools are about, in my lifetime, I have never seen the educational system as well off fiscally as they are today. So if these cases have a correct theory of what makes for good education, we should be seeing fabulous schools in the next year.
Well, I guess we'll see. I think the next chapter in these cases is learning loss, and the next chapter in these cases is going to be okay. Well, we had this set of policies that resulted in schools being closed for a year in many places, not all places, but many places, and we're now beginning to see some studies coming out which validate that, sure enough, kids learn better when they're in school. And so we have these deficits now in student performance that are going to be highlighted undoubtedly when the NAEP gets released here shortly. And the argument will be, this was without anyone probably taking responsibility for it, this was not a good policy or set of policies, and look at the result that it produced. And we've got to do something about it. And we've already seen some, what I would say, back of the envelope, and maybe that's being generous, but back of the envelope ideas presented that it's going to cost $700 billion to $1 trillion to overcome these learning losses. So I think on one hand, not to talk to the economists in this way, on the one hand, you're absolutely right. We are seeing greater funding in schools than ever before. But at the same time, we're going to see undoubtedly really bad performance here on NAEP. And the advocates on the other side will say, this was a once in a lifetime terrible thing. And there's going to be advocates who produce studies saying, here's what we estimate the cost would be to fix that. And we're not funding it currently enough. So I think that's probably how it plays out.
Well, that raises the other issue. I know that you were involved in Florida in defending the governor who actually said the schools must be open, which was different from what the policy was in many other states, California, New York, and Illinois, where they closed the schools for another year in many of these places. So, and then the governor was sued for this, and so you were defending him. And so, what was the case against opening the schools? What was the legal case against opening the schools?
The legal case really was based on the Florida Constitution, and it had to do with a couple provisions. One was the safe, secure language, which we highlighted. And the argument was, even though it was voluntary for students to go back to school, and this was in the 2021 school year, it was voluntary, but the policy was that schools had to be open in person 5 days a week. And the argument from the plaintiffs was, well, they're not safe to be reopened in person. And so it was taking off the Florida Constitution. And the second argument was that local school districts should make this decision, not the state. And so it was about within the state, sort of who has the authority. And under the Florida Constitution, the decision ultimately by the appellate court was these are policy determinations from the people's elected representatives and governor and so forth, and that we're not going to delve into what's right here because these are not settled issues, and we're in the middle of this uncertain situation. And there's, again, views on both sides of this about can you open schools safely? Many private schools had been open. A lot of public schools, and we now know, were open, and were open in a way that they managed to do so successfully. But that was the nature of the case, and that was the determination ultimately, is that that the court felt that this was a policy determination.
So it was in some ways like the decision in Florida on the adequacy lawsuit that really the courts can't get involved into every policy issue in education. You've got to defer to the elected officials, and the court should be cautious before they enter into that space.
Yeah, I mean, that was the gist of the decision. And, I mean, ultimately the argument here has been, if you don't like that, then go vote these folks out, and have different policies. And so that's whether it's at the local school board level, whether it's at the legislative level, or at the executive level. And frankly, that's faster. Look at the New Jersey case. It's been 30 years of litigation. And you say, well, it takes too long to vote people out. Well, maybe that's actually faster in terms of getting to resolution.
Yes, well, the wheels of justice do grind rather slowly, I think. So thank you very much, Rocco Testani, for that excellent presentation. We look forward to you all 1 week from today when our next seminar is being held.